Indian news ma kwaba assign the ba wan kasa fidie so bio. Na maka trust before anything else na just a share na ebiem so kwa na wo subscribe to your channel no. What's the political news there? Never governance. We catch you sa pan put to forma yet. Na pan to forma yet there. Ane na nsɛm foforɔ bi nso asan asi. Benim sɛ wo de nsɛm a de ba nyinaa no ya na ya wo tɛ na ya wo hwɛ na ya wo fɛ nso so. Nti no nsɛm foforɔ bi asi a Nimdeɛ news yɛn nso so pane yɛ tɔɔfo mi baabi yɛ ti nyinaa akyi no yɛn nsa atumi aka bi na yɛaso nso atumi ate saa nsɛm bi. Yɛntie nsɛm mmra sisi a na mpanimfoɔ mpo sɛ kakum no yɛgye no kɔkɔɔ anum. Deɛ ba before that no subscribe to yɛn channel no. Ɔmsa bɛka all other news a ɛfa politics wɔn de deɛ wɔpɛ sɛ wotie no ɛho. Yɛtie ba yɛbɛn baabi a susu nso pɛ so wɔde bɔde wɔn fa. Na deɛ asie biara no nso fa comment nso to aseɛ na yɛnkenkan mfama wo deɛ yɛhwɛ de nneɛma ɛkɔ. Yɛntie nsɛm mmra sisi a wotie no fa comment to aseɛ ba a yɛmfa nkyerɛmu no nso ntoa so. Yɛntie mmra.
Going on, I'm going to give you the brief and then we are going to go into the response. Enra ena eye ekuo bi a wɔn say wɔn yɛ England for lawyers ekuo England and the Commonwealth. What you say na mama what you say Commonwealth they say Commonwealth country a not just say countries a eye England for edi so no ye nyina ye Commonwealth for. Na enra na yete say yesi ekuo bi a omo ye lawyers a womu free saa amanaman we mu no omo aba betro nkrata a womo ema His Excellency John Dramani Mahama order say Chief Justice Getro talk on a ya suspending no Mahama enye no nsanso emfa ne mbra biom na dia Mahama eye no etiambra. Even though it has gone to Supreme Court, the Supreme Court has ruled say His Excellency John Dramani Mahama de oye ni nano it is according to law on tiambra biano enkrofo with so much so mo de omunim esen Ghana yenye Supreme Court. And for people who don't know, Ghana Supreme Court ena etre emrase. The sole role of the Supreme Court is to interpret the Constitution. Supreme Court na etre emrase. It is a Supreme Court na etre emrase. Now what they also ye England for lawyers. So person try and say unim saying yenye Supreme Court. It is not just an insult. It is not just only an insult. What you say, but you see, it's more like it gives that classism, elitism energy, condescending intimidation energy. Biasa the officer just say, "Oh, the nipa esin ubi. Oh, the unim sin yenye Supreme Court. Unim sin yenye judges, right? Basically, but the Attorney General, the Office of the Attorney General, oman chahu, in some nebaya 1 hour, and check." The Office of the Attorney General had a response ababa betuja. Na the Attorney General is kulisa nkrofo ye. Yen read the response Attorney General no e de ebae na yen hwe Attorney General nsɛm a wono so aka. Wo say press release. The Honorable Attorney General's response to the joint statement by the Bar Council of England and Wales and Commonwealth Lawyers Association on the suspension of the Chief Justice of the Republic of Ghana. Also, this is the response by the Honorable Attorney General of the Republic of Ghana to the joint statement issued by the Bar Council of England and Wales and the Commonwealth Lawyers Association on August 14, 2025 regarding the suspension of Her Ladyship Justice Gertrude A.E.S. Tokonu, CJ, from the office of the Chief Justice of the Republic of Ghana. 1. Also, the government of Ghana acknowledges the joint statement's expressed concern for judicial independence and commitment to constitutional governance within the Commonwealth. It is, however, a matter of serious concern that the BCEW and the CLA issued the joint statement without first acquainting themselves, even in a very basic way, with the relevant constitutional provisions and the material facts of the matter. Now, Obi Biara Otie, the analysis I did, no, me reading Crawford and Crat, and as someone met Tremon and Crawford and Cran as a Ghana ran no moonim, Munyamokai. Emma, my yes, second video, no cram, matress and Crawford no moon kuti Ghana rani ye. That is a more Kasake, Ghana ran a cran no moonim. I did the analysis, I said that because that was the first thing. Me read your moon no. That was the first thing I could arrive at. And it's not surprising, say, in the response of the Attorney General, no, the number 1 point, and one son Attorney General no worker. Attorney General is a more can say, now more someone more crano, Say Ghana mrano kramuni. Attorney General no person tre say in some way mo kan Ghana mrano kramuni na nka say musua Ghana mrano mo kinkan Ghana mrano na mo tim mrana si yansa na mo kasa because clearly any person who reads that statement will know say angrofo we in some mo kan no mo nim Ghana mra. And so I'm happy that the Attorney General is also siding with in some way so me kind the first point I me make and no answer Attorney General they make. Now the second point I'll say the suspension of her ladyship. No, before I go to the I'm getting too excited over this response. I'll bring you I'm getting to a response. I'm let me cool down and read it well. But answer no, Mr. Obi a wutie me bia no, wa wutie me no, you know yourself. Unimu ho. Se we fu asha se eye kese. And awasha se who put the suspension of her ladyship, Justice Tokonu CJ, strictly adheres to the provisions of the 1992 Constitution of Ghana, particularly Article 146, which prescribes the procedure and grounds for the removal of the Chief Justice and the removal of other justices of the Superior Courts from office. This process is clear, comprehensive, and has been faithfully followed, as set out in the steps described below. Into the second point, we're trying to say, Sabe, yan sorry sa keke, and Chief Justice, yes, ye know. Ye bia na yembra na yedi mmra so na wo read Ghana article 146 na wo be hu ne say ye bia na yembra mmra na yedi so no eni the procedure under article 146 was triggered by 3 separate petitions filed by citizens of Ghana alleging stated misbehavior and incompetence on the part of her ladyship Justice Tokonu CJ. Inti ngrofo miensa ekuo miensa ene share petition ase se maame no wa ye nyama bi a ensem fata se o se Chief Justice o ye emra no so tre se Chief Justice ya di ensem fata se o so ya e was nkrofo petition. B. Following the receipt of the petitions, the President acting under Article 1466 and in accordance with the decided cases of the Supreme Court of Ghana referred the petitions to the Council of State for their advice on whether any of the petitions discloses a prima facie against her ladyship. Justice Tokonu CJ. The Council of State is a body of eminent persons chaired by a former Speaker of Ghana's Parliament. Membership of the Council of State includes a retired Chief Justice, a retired Inspector General of Police, a retired Chief of Defense Staff of the Ghana Armed Forces, a former Attorney General, retired Justices of the Supreme Court, eminent traditional leaders, and elected representatives of each of Ghana's administrative regions. And I like what the Attorney General is doing here. The Attorney General is sort of letting England lawyers know. Say, se munim Ghana mrana ye tremo Ghana mra. Ghana mra ne tre se president eti enya petition na. Eni kwen se president no eye se ono ankasa ekwa yi Chief Justice no. E was say president no. O sha ase ekokohu the Council of State. Na Council of State may be decided. Into we no say Council of State no say be enya kwahwe kwafo bia. A former Chief Justice eka ho. Former leader of Parliament and Speaker of Parliament eka ho. Former IGP eka ho. Former retired justices of the Supreme Court eka ho. Traditional Sankrofo atrom say decision we no say Chief Justice no ene aba mo nchen aba be ka kire mo say ade we ene emfa mra kwan so a yen ye kire mo say ade a esi ye no enye nkola bi na ekokote na be bi decide say maame ni ye yi no eye mpanyimfo na atena se ehu ne sensem a ye de ato maame ne so no eye nsem a eye serious. OCC copies of the petitions were sent to the Chief Justice for her preliminary response, and upon receipt, the President forwarded copies to the Council of State. After considering the responses, the Council of State found that each of the 3 petitions establishes a prima facie case against her ladyship, Justice Tokonu CJ. To tremu because ohwe ngrofo ne nkrata na omde bae na assemble akomo samso kan ne say as a president no ama Chief Justice na training nsemu. Inti Attorney General ne nkrata na etre se dabi president no eden nsem ne ma Chief Justice. O ma Chief Justice ne training nsemu. Or then the response by no. Yeah, the response no so sound so combine Council of State. controversy case was established, the president, in consultation with the Council of State, constituted a committee to inquire into the matter as mandated 146. The committee comprises 2 justices of the Supreme Court, one of whom serves as the chairperson, and 3 other members who are not lawyers, members of parliament, or members of the Council of State. Into what trade President no Council of State for me prima facie ewie no and a president no eba for me a panel say ye investigate na panel no mo investigate no enye obi akeke chief justice nankasa colleagues and etia no. So you see the explanation into unim kra unim. I say after establishing the inquiry committee, the president, acting in accordance with further advice from the Council of State as provided for under Article 146(10)(a) of the Constitution, suspended her ladyship, Justice Tokonu CJ, from the office of the Chief Justice pending the outcome of the inquiry. And I've read this on this platform in the video I just posted. Me read it ewum. Omo say, no president no Article 146(10)(a) what say president in suspended Chief Justice no. And no na president ne ye. And this was when Engrofon Nkrata no more say Ghana Mrani say the only time I obey Chief Justice and say oh yeah ready until ye Chief Justice no. Into more trend said that be Article 10(a) ne say president can go forward to suspend the Chief Justice after all the processes no were respected. And the president indeed has done so. I say the government notes the joint statement's reliance on the Commonwealth Latima House principles. Ghana's constitutional framework is not only consistent with these principles, but also provides robust safeguards for judicial independence and procedural fairness. The process under Article 146 of the Constitution ensures that the president does not act unilaterally, but only upon advice and findings of constitutionally mandated actors and independent investigative bodies. The president does not participate in the inquiry, and by Article 146(9) is bound by findings of the inquiry committee. Nkrofone nsem omo ka no omo ka se omo mmra e no ka se o mmra ne de yate Ghana ha se yenso ye wo mbra yenso ye yusu na wo hwe Article 146 ne kra na sa Article 146 no o read kra na president no need to me. And I've discussed this. Semunia Mobekaya case we share earlier this year no. I discussed the Article 146 in its entirety. Emma mema motiasie say, o hwe the wording of Article 146 ne kra na president can need to me. Because now say constitution is share president. Say so we see it will hear His Excellency John Dramani Mahama kra na only to me, and indeed that is what the Attorney General is saying here. The president is binded by the constitution to carry out in somewhere investigative bodies no edebeba only to me a obeka so investigative body no say ninti menye dabi. I say 4. Regarding concerns about representation and participation in the proceedings, the Attorney General is confident that the inquiry committee established under Article 1466 and chaired by the Chief Justice's peer, a Supreme Court justice, is acting within the bounds of the law. We also believe that the Chief Justice, like any other Superior Court justice subject to such proceedings, receives all the protections available under Ghanaian law, including the right to legal representation of choice and the right to fully respond to the allegations. Nkrofo issue I want to raise here, and the Chief Justice ni complain say or committee ne so or inquiry board ne so na investigative board ne so a said ye ne yakayaka de bi e no mo ka say ono ane nkrofo a oni omu ye adwuma na ete committee na no nsemu amo ka so ye ne ya o ti be bi ka so ye obi yakayaka de wehu weni aboso ono ane nkrofo na ete so na eyemra ne nkrofo ne nso no you see Chief Justice no dey asem na kwa dan Supreme Court judges ne nsemu amo ka ne say. And sa same way asem we me say obi bia wo nim Ghana mra bia no wa we follow me channel we mra asem we share no me sure say we hu Ghana mra ni mu kra because na asem we so ma ba be read other mra kra e tre say Committee of Inquiry Tenasia, they have the right to set their own rules. Muni amoka isa asem no. To address a committee ni rules a omo set no. Eyemra. Enya se committee ne pe. Intia na me say Chief Justice no dia kokoda in Supreme Court. Di intia. Why is it that omo throw letter no? They are not speaking about the Supreme Court ruling. The third point, also as to suggestions of delay or procedural impropriety, it is important to emphasize that the committee is wholly independent of the executive arm of government and conducts its work in accordance with its own procedural rules, consistent with the constitutional principle of legality, fairness, and reasonableness. By the provisions of Article 146, all proceedings related to the removal of Superior Court justices are held in camera, and the President, like all other citizens, is not privy to them. However, it is unrealistic and unbelievable that an inquiry committee with two of the suspended Chief Justice's peers, one serving as chairperson, would deprive her of the safeguards of due process, particularly when it is public knowledge that legal counsel comprising distinguished legal academics and practitioners has continuously and ably represented her throughout the hearings, bearing in mind that the proceedings commenced only on May 15, 2025. Any suggestion of undue delay is, to put it mildly, grossly misplaced. Nti nsɛm a wɔka, maame ne nsɛm a wɔka, ɛna yɛ entreaty ne yie, ɛna yɛahyɛ da ne yɛbɔ delay tactics, ɛna yɛyɛ sei. Ɔse ade kra May 15th ya, ɛna adeɛ no hyɛ aseɛ. Maame no ne colleagues mienu ɛna ɛte board ne so. Nti no Attorney General ne ibisa England for judges nti mususu sɛ maame no Supreme Court judges nnamfofoɔ ana ɔmo ɔne ɔmo yɛ adwuma mienu ɛna ɛte board ne so no. Ɔmo bɛhwɛ na maame no yɛayɛ no yakayaka de ana. Mumu adwumu no mo hwɛ a yɛbɛhwɛ na maame no yɛayɛ no yakayaka de. Odi ɛsɛ yɛ no mpo na mo bɛka. Obi anim sɛ maame lawyers bebree are representing no. Obi a otie ɔkɔ obi a wonim sitting no the air cost bia no enim se maami lawyers bebree akọ representing no wo ho ya mo kwan mo akọ but nti oba abontin na oba be kasa te se de ye ma ne kwan na mo nso mo asom se ye ma ne kwan na ye ma ne kwan a ma nya mo se ye nkola nyama bi ne ye wa ha na nkola agro bi ne ye dio omo te board ne so omo nya nkola omo nya nkola mbetena ase ahwe se maami yebedi na abro sa. The sixth point, it must therefore be emphasized that there has been no constitutional breach or executive overreach in the consideration of the three petitions. Applications for interlocutory injunctions and judicial review brought before both the Supreme Court and the High Court by the suspended Chief Justice and her associates in an effort to restrain or halt the inquiry committee proceedings have been duly considered and dismissed by the court as lacking in merit. We feel considerably reluctant to mention that the sound, including the very words of the BCEW and CLA joint statement, vividly clones the dismissed grounds which her ladyship, Justice Tokonu CJ, and her associates canvassed before the Supreme Court and the High Court. It's also important to mention that Justice Tokonu CJ has presented similar arguments in her case before the ECOWAS Court, which the government of Ghana is defending on behalf of its citizens. And you see exactly what I said. Embra me reading Crawford and Crat, and as someone me kind of say, my men someone will raise and one as England for lawyers in Sweden. And that's exactly what the Attorney General is saying here.